This is so stupid. So that is the thing about the after issuance. So they have to be served within 2 court days after their issuance. And if they can't be served, such fact shall be reported within 3 court days after their issuance, and the court shall issue a warrant. This is only for cases involving abuse where the respondent is not outside the state. Okay, because issuance of a warrant shall not be required where process is sent without the state. Now, B says that they shall be delivered to the person summoned at least 24 hours before the time stated in for appearance. So that's different than after their issuance. Then it says, in cases involving either abuse or neglect, court may send process without the state in the same manner and with the same effect as process sent within the state. In the exercise of personal jurisdiction over any person subject to the jurisdiction of the court under 301 or 302 CPLR, notwithstanding the person is not a domiciliary or resident of the state, where the allegedly abused or neglected child resides or is domiciled within the state, and the alleged abuse or neglect occurred within the state. So you need both of those things. Child lives here, abuse and neglect occurred within the state. Now, in cases involving abuse only, where service of a petition and summons upon a non-resident or non-domiciliary respondent is required, such service shall be made within 10 days after issuance. If service is not effective within 10 days, because it can't be, an extension may be granted upon good cause shown, upon application of any party or the child's attorney. So yeah, it's different for abuse versus abuse and neglect, or neglect.
Whenever a person receives a sentence of imprisonment, the court that has sentenced such person shall deliver the certificate of conviction and provide notification of the sentence imposed to the Commissioner of Social Services. How I don't remember that, because the certificate of conviction is also like the commitment when they go to jail, I don't know. But it's sentence of imprisonment. And I should have known that. 1, 3, and 4.
Yeah, read that one.
Okay. Which, if any of the following are true concerning interim probation supervision, which I do almost every fucking day. 1, the court must determine that the defendant is eligible for a sentence of probation. 2, the DA must consent. And 3, No. The court may adjourn?
The DA doesn't consent, it's D.
Oh, fucking. And I got it wrong again! I fucking got it wrong again! But I know it's not the DA must consent, because the judge can say, fuck you, I'm doing this anyway. So I don't even know why I would pick that. Okay.
Which are true.
Okay, which, if any of the following are true concerning interim probation supervision? 1, the court must determine that the defendant is eligible for a sentence of probation. 2, the defendant must consent. And 3, the court may adjourn sentence to a specified date and order that the defendant be placed on interim probation. In no event may the sentencing be adjourned for a period exceeding 1 year from the date the conviction is entered.
Now, who does not have to consent?
The DA does not have to consent, because even if they don't want that, the court can just say, like the judge can just say, I want this done today. Fuck you guys, I'm just doing it. And that's it. Great. In order to establish or modify a support order of another state, a petitioner must first register the said order by sending which, if any, of the following documents and information to the appropriate tribunal of this state. 1, a letter of transmittal requesting registration and enforcement. 2, 2 copies of the order to be registered, 1 certified. 3, sworn statement showing the amount of arrearage. 4, the name of the obligor. 5, obligor's address and social security number, if known. 6, name and address of obligor's employer and source of income. 7, name and address of the obligee, and if applicable, the agency or person to whom support payments are to be remitted. That's it.
Rule 205.43, which I'm not even sure is definitely on the test, but just in case it is, if a willfulness hearing for willful non-payment of child support is going to be had by a support magistrate, at the conclusion of the hearing, it shall issue written findings of facts within 5 court days. If a willfulness hearing has commenced and must be continued, the adjourned date shall be within 7 court days. I know, that's probably why they put it on the test, so they can make easy questions out of it. Okay, so the first thing that this says is a submission by a support collection unit pursuant to 413 shall include the following, which shall be submitted on forms promulgated by the fucking chief administrator. 1, an affidavit from the support collection unit, which I'm going to abbreviate as SCU, with findings in support of adjustment. 2, a proposed adjusted order of support. 3, a notice to the parties of the proposed adjusted order and the rights of the parties, including the address of the court and the SCU. The documents set forth shall be filed with the clerk of the court, so that's the clerk of the family court, within 10 days of mailing to the parties, together with an affidavit of service. Where a written objection is received by the clerk within 35 days, the court shall schedule a hearing upon notice to SCU and the parties. Where no timely objection is received, the court shall sign the order upon being satisfied the requirements of the social services law have been met, and transmit copies to SCU for service on the parties. Absent unusual circumstances, court shall sign the order or dismiss application within 10 business days after conclusion of 35-day period. So now 205.43 is talking about the petition that alleges a willful violation or seeks enforcement of a support order shall be scheduled as soon as possible. Can you read that thing about the 30? I can't even see it. For a first appearance.
Over here?
Yeah, and then next, it's like, what does it say about just on the other side of it? Date in family court.
What are you talking about? Where?
The 30 days.
Oh, first appearance date in family court. But in no event more than 30 days of the filing of the violation or enforcement petition. B. After service is made, the judge or support magistrate must commence a hearing to determine a willful violation within 30 days of the date noticed in the summons. The hearing must be concluded within 60 days of its commencement. Neither party shall be permitted more than one adjournment to secure counsel, except for good cause shown. On the scheduled hearing date, on the issue of willfulness, the hearing may not be adjourned except for the following reasons.
Okay, now I can see it.
Okay.
The actual engagement of counsel pursuant to Part 125 of this title. 2, illness of a party. Or 3, the catch-all, other good cause. No adjournment shall be in excess of 14 calendar days. If a willfulness hearing has commenced and must be continued, the adjourned date shall be within 7 court days. At the conclusion of a hearing heard by a support magistrate, the support magistrate shall issue written findings of facts within 5 court days.
And this is for willfulness of
Failing to pay child support.
So it's like they
They had the money and they just
purposely
didn't want to
don't-
pay
Okay.
it. Okay, and then it says something about a money judgment, a recommendation about incarceration, specific facts upon the finding of willfulness, a recommendation of a dollar amount to be paid to repay the arrears. I don't even know what the hell it's talking about there, but because if they're going to put the guy in jail, the support magistrate can't even do it. Does that make any sense to you?
No.
Okay.
I hate this.
It shall continue through the confirmation proceeding before the family court judge without further order. I have no idea what the fuck that's talking about. Whatever. Remember, 7 court days for the adjournment, I think. No, 14 days, 14 calendar days for the adjournment. The hearing, oh, no, wait a minute. If the hearing, okay, so if the hearing hasn't commenced yet, the adjournment can be up to 14 calendar days. If the hearing starts, the adjourned date has to be within 7 court days. And then if the support magistrate does the hearing, which I'm sure they're going to kick it to him, he's got to issue written findings of facts within 5 court days.
And the hearing has to be done within 30 days. Note the date noticed in the summons, and the hearing must be concluded within 60 days of the commencement. I guess it's that one.
A support enforcement agency means a public official or agency authorized to seek 1. Enforcement of orders of support or laws relating to the duty of support. 2. Establishment or modification of child support. 3. Determination of parentage. 4. To locate obligors or their assets. Okay, and to read it directly out of the book, it says support enforcement. This is actually in 580-102, subdivision 27. Support enforcement agency means a public official, governmental entity, or private agency authorized to 1. Seek enforcement of support orders or laws relating to duty of support. 2. Seek establishment or modification of child support. 3. Request determination of parentage of a child. 4. Attempt to locate obligors or their assets. Or 5. Request determination of the controlling child support order. Proceedings to compel support under Article 4 may be originated in the county in which one of the parties is domiciled or where they reside.
Okay, I'm ready. Which of the following are true? In general, a subpoena requiring attendance or a subpoena ducis tecum shall be served in the same manner as a summons. 2. In general, after a subpoena is served, proof of service need not be filed. 3. Any person subpoenaed shall be paid or tendered in advance authorized travel expenses and 1 day's witness fee. 4. A copy of any subpoena ducis tecum served in a pending action shall also be served on each party who has appeared in the action so that it is received by the parties promptly after service on the witness and before the production of books, papers, or other things. That's right, because you told me the first one was...
You serve the witness first, then you serve it on the other people. In general, during and after trial, disclosure may only be obtained on notice with a court order from the trial judge. There you go.
Notice under Domestic Relations Law Title VII shall be given at least 20 days prior to the proceeding by delivering a copy of the petition and notice to the persons to be served.